Hello, I'm Bridget Blinn Spears, and I'm an attorney at Nexen Pruitt working in employment and labor law. Public support of unions is at an all-time high, and President Biden has publicly said he wants to be the most pro-union president ever. Unions are making high-profile headway into places where they have historically struggled, including companies like Starbucks and Amazon. As unions become more the norm in today's business environment, it's important for business owners and managers to know that the law restricts what companies, through their supervisors and managers, are allowed to say during a union campaign. Companies must avoid threats, interrogation, promises, surveillance, and discrimination. These can be remembered through the acronym TIPS-D. Threats. Employers cannot tell employees that workers will be fired if they vote for the union, or that it will close a location in response to a union campaign. Don't threaten to reduce pay or benefits or discipline employees who support the union. Interrogation. Companies are not allowed to question employees about their union support. They cannot ask for names of union supporters or poll employees to see who does or does not support a union campaign. Don't ask employees how they plan to vote or whether they have signed union authorization cards. Promises. The opposite of threats is promises. Employers can't promise to raise pay or provide additional benefits if workers don't vote for a union. They can't promise to address issues raised as part of the union campaign or provide promotions or other benefits to employees who don't support the union. Surveillance. Companies are not allowed to conduct surveillance of employee union activity. Don't take pictures of employees at union meetings, take down license plate numbers, or listen to employees' conversations about organizing efforts. Supervisors and managers should decline any invitation to a union organizing meeting. They're not allowed to join unions anyway. Don't do anything that looks like spying. Discrimination. Lastly, companies cannot discriminate against an employee for participating in union activity or engaging in concerted activity or collective bargaining with coworkers, even outside a union campaign. Companies are allowed to share their views on unions, but must strategize carefully to make sure their communications don't fall into prohibited categories and aren't misinterpreted by employees. Companies are allowed to share facts, opinions, and personal experiences and examples. These can be remembered through the acronym FOE. Facts. Companies can share facts that are verifiable through public resources like legitimate news reports, government websites, court cases, and the Center for Union Facts. Companies can also educate employees about what the company and the union are legally permitted to do during the campaign and after. Opinions. Companies are allowed to share their opinion as to why they view unions as unnecessary, as long as they avoid framing that opinion in terms of the TIPS-D allowances I spoke about earlier. Personal experiences and examples. Some supervisors and managers may have been union members earlier in their careers, and they're allowed to share, factually, about their own experiences. Companies can also provide examples of cases where union officials failed to act in the union's interest, like the SEIU's operations manager who pled guilty on July 1, 2022 to an embezzlement scheme that generated more than $500,000, including through personal use of her union credit card. You can also share examples of how the company has historically positively resolved issues with employees without union involvement. If a union does try to organize your workforce, it's important that your supervisors and managers understand what they can and cannot say from the very beginning. And it's also important to get solid legal guidance through the process. The employment and labor lawyers at Nexen Pruitt are here to help you work through challenges with your employees, including union campaigns, in a practical, legally compliant way.